Hello friends, welcome to our YouTube channel Induslex Magnus Associates. Dear friends, today we are going to discuss what would be the appropriate procedure to get bail of a juvenile. Dear friends, as we know, in the cases of juvenile where the juvenile has committed any offense, that the maximum punishment prescribed by statute was 3 years. But as law changes, that the Juvenile Act classify, or you can say make the category that a particular offense in which maximum punishment prescribed by statute is more than 7 years. More than 7 years. If the offense committed by a juvenile who is below 16 years, on conviction he would be awarded maximum punishment of 3 years. In a cases where in IPC the maximum imprisonment prescribed by the respective offense in the statute is below 7 years and the juvenile is also the below 7 years, then in that cases the maximum punishment can be given at the stage of conviction is 3 years to the juvenile. But as the law changed, and if the name of the juvenile came into the light in commission of the offenses which has more than 7 years, and his age or her age is between 16 to 18 years, then the juvenile board will conduct mental examination, and after conducting the mental examination they will hold the juvenile as that he is capable to understand all the consequences as like an adult person can understand, and such the juvenile board order for the trial should be conducted as adult. In the cases where the juvenile is of age of 16 to 18 years and he has committed or his name has come in the FIR or in the charge sheet or in the case in the category where the offense prescribed by the statute, punishment prescribed in the particular offense by the statute is more than 7 years, and if the juvenile age is between the 16 to 18 years, after the conduct of mental examination by the Juvenile Justice Board will order that the trial of this juvenile should be done as adult. So dear friend, whenever you know the juvenile, that before getting bail, don't try to declare that the particular accused is juvenile without getting declaration from the Justice Board that the accused is juvenile. Firstly, you have to directly approach the session court for the bail, and if the session court reject your bail application, you should approach Honorable High Court for the bail. It is because if you went to the Juvenile Justice Board, that the JJ Board, and said that listen, this accused is juvenile, then they will reject your bail application because of age that is 16 to 18 years and the category of offense that is heinous one. Then the Juvenile Justice Board will reject your application of the bail application. Then you further approach to the session court, and in session court also your bail application would be rejected because in the same cases where when the application of bail of particular individual adult came before the session court, on that facts and circumstances session courts, after applying judicial brain, reject the bail application, and that is why your bail application of your juvenile which is already rejected by the Juvenile Justice Board, and you approach the session court in appeal under Juvenile Justice Act, and then session court after applying their judicial mind reject your application, and you have to approach further to the Honorable High Court. Meaning thereby, friend, in short, if you approach Juvenile Justice Board at the first instance for the bail application, you have to further take 2 steps, one before the session courts and then to the High Court. But if without declaring your declaring the accused as juvenile, if you properly file the bail application before the session court, and if the session court not grant you the bail, then you can move your bail application by way of criminal revision before the Honorable High Court. By this way, you will save your money and energy, and you get relief in a lesser time compared to you firstly approach to the Juvenile Justice Board, because in the practice the procedure to get declare a particular accused a juvenile is a very time taking process. Further, the judges, the judicial officers who has the responsibility to decide your application, they have lot of pressure and you can say there is some unknown reasons why they dismiss the bail application of the juvenile at the preliminary stage. But in fact, dear friend, the best solution is always that without getting declared the accused as juvenile, you approach session courts, and if you fail there, then you directly approach the Honorable High Court. And it is important to know you that the claim of juvenility you can raise at any stage. You can raise it at the stage of charge, you can raise it at the stage of 313, you can raise it at the final hearing stage during the trial, even you can raise this right at the appeal stage. Dear friends, in the next video we will bring some more informative information to you viewers. For the meantime, you may subscribe our channel, like this video and share as more as possible. Thank you.